What happens after filing my trademark? Well, what happens after you file a trademark application? Well, nothing immediately, as the Trademark Office may take about 6 months or more to finish examining the application. In many cases, you'll get what's initially called an office action. This is a preliminary rejection from the Trademark Office, either asking for clarification about something, maybe the goods that you described have something wrong with them that needs fixing. Other times, the office action may be based on absolute grounds of refusal, where for example, you're asked to prove that the trademark has acquired distinctiveness because it's determined to be quite descriptive. In other instances, some offices may use relative grounds of refusal in their office actions. Typical of this is citing another trademark that has a filing date older than yours and saying, "We won't give you a registration because of this prior registration." In the event this happens, you will be given a certain time limit in which to respond. There are times when you can just call the trademark examiner and say, "I received this in the mail and need to know how we can fix this." If it's a minor issue, they may correct it over the phone or by email. Otherwise, you will need to submit a legal response within the time limit that was given to you. This is often a good time to seek the help of a trademark attorney or trademark agent, such as TradeMarkers. The legal response submitted will often disagree with what the Trademark Office is saying. Maybe they think that the words of your trademark are simply describing the goods for which your trademark was filed for, like descriptive, and you need to convince them otherwise. Perhaps they have cited a prior older trademark against your trademark, and they believe it is likely to be confused with your new trademark, and you now must convince them otherwise. Now, these issues can usually be argued on both sides, and you will need to present a submission that has a strong legal argument for your case with the Trademark Office. In the event that you win, then your trademark will move on toward being registered. If you lose, then your trademark will either not be allowed registration or allowed a partial registration according to how successful you were in your legal arguments. Now, some jurisdictions will let you appeal the decision to a board of second instance. In the U.S., for example, this is called the Trademark Trial and Appeal Board, TTAB. Here you can be given an opportunity to present your case to the TTAB and let them review the decision of the trademark examiner. If your trademark application is approved, it will then be published for opposition. This gives third parties an opportunity to see your trademark application and determine if your mark will cause their mark to be injured or damaged, and then to oppose your application or not. If they believe your trademark is similar to theirs, then you could have an opposition on your hands. However, if the trademark application is unopposed for 30 or 60 or sometimes 90 days, depending on the jurisdiction, then the trademark is allowed to be registered. At this point, in the EU and certain other jurisdictions, you will be given a 3 or 5 year grace period during which you should be making use of the trademark and making genuine use in trade of the trademark you have registered. In the EU and certain other jurisdictions, after that grace period of 3 to 5 years, your trademark becomes vulnerable to cancellation due to non-use. That means if anybody wants to challenge that your trademark was not being used during the post-grace period, your mark could be deleted from the registry and you will lose your rights. While it's true that a trademark office does not remind you of these dates, it is your own responsibility to make use of the trademark so that if anybody challenges it, you are ready to prove them wrong and keep your trademark. In the USA, it's very different. You cannot register the trademark until it is already being used in interstate commerce. And with very few exceptions, you must always be using your trademark while it is actively registered. Else, you are susceptible to having a cancellation action filed against your mark and losing your rights. Trademarks are to be used, not simply collected, and most countries have similar laws that allow the cancellation of unused trademarks. Trademark rights can continue in perpetuity. They can go on forever, as long as you continue to use the trademark. But the trademark registration actually requires maintenance fees. It's the governments that control the rights and fees, and they will make sure that they receive something in exchange for keeping the trademark active. So they implement what's called renewal fees. In addition, renewal fees are a good way to make sure that the trademarks are abandoned when a business has also ceased to operate. The initial renewal fees are due between the 5th and 6th year of registration in the U.S. and about 10 years later for other jurisdictions. Some offices remind you of the approaching expiration, others don't. In either case, make sure you mark it on your calendar, else hire a lawyer to keep track of it for you. Some jurisdictions, like the U.S., also need a declaration that needs to be filed at the time of the trademark renewal that says, I am continuing to use this trademark and will do so going forward. And here's a specimen that's evidence that I continue to use this trademark. Now, as long as you follow the rules and pay the fees timely, you can potentially continue to renew your trademark forever. Please feel free to watch more of our videos to get valuable insights about the mechanics of applying for trademark registrations, defending your marks, opposing other conflicting marks, dealing with office actions, and many other intellectual property issues. My name is Jonathan Morton, and I am a licensed U.S. attorney and a member of the TradeMarkers Network. Don't forget to subscribe.